Hello, my name is Yamil Francisco with the World Florida Online. And I am getting some stuff ready to be mailed for other clients, but I wanted to address some of the questions that I'm getting this week. This is actually my first Q&A live, so I'm planning to do this every Tuesday going forward, addressing the questions that I'm getting. Sometimes the questions is the same, but sometimes, I'm trying to do a live address a different question. So the first question that we have that I wanted to address is that I get a lot of questions about child support. How is that calculated? So I'm moving my hands, I'm doing stuff. So there is on focourts.org, there is a form called child support guidelines. And you can actually take the both incomes and the different criteria, fill it up on the form, and it has a table as to where the sliding scale is. So I mean that is the most basic explanation. So what we do, if you don't want to do that, there is actually a link there to a calculator that is already, you should enter the numbers and it should calculate the numbers automatically. There's also another one, I didn't look for it, but there's an attorney out there in Florida that actually has a pretty cool tool. And you do put the things, it doesn't look like the child support guidelines form, but it spits out the numbers. So that is very useful. But basically, what you need to know is both incomes, and that's net after taxes and deductions. Well, the deductions that apply would be the taxes in medical insurance, and if there is child support from a prior relationship, court ordered. That's very important, not because, oh yeah, I give my ex baby mama $300 a month. We're talking about court ordered. And then, so it would be the net income after that, after those. So it's taxes, union, if they have to pay a monthly fee for the union, and medical insurance, not if there's a 401k deduction, not if they're going to be able to make income out of that deduction. So only those kind of deductions. That's the net income for both parties. So you'll need the dad and the mom, or the mom and the mom, whatever, and then you'll need to know that for both parties. If it's unemployed, it's some courts do it differently. Some courts will use the last employment as an average. So let's say that you used to be an IT engineer and you were making $60,000 a year. That's pretty much what they use to input income. If if you're disabled, employed, you haven't been really stable or have no education, that sort of thing, so you don't have any prior history significant, then they would use minimum wage. So that's usually how it's done. Then the next thing is that you have to know if there is any daycare expense. So if, let's say, the mom is paying $400 a month, then the child that her she would get the the credit of paying those $400 in daycare, and then it's going to be split up based on the percentage of each income. So let's say I made $2,000, my ex makes $4,000, so I'm going to be responsible for less percentage than he is because he makes more money than I do. So let's say, for example, so he's responsible for 75%, I'm responsible for 25% out of the $400 a month. And then, so depending who's paying it, depending how the breakdown of that works. And then same thing with medical insurance. If the child is on Medicaid, it doesn't apply. But if the child doesn't have any insurance, it doesn't apply. But it does apply if it has, one of those scenarios. To give you an example. Medical, also out of pocket medical expenses such as braces, usually they're not covered by Medicaid. Any other type of medical related expenses that they incur on a regular. Those are not usual, but things like braces, what comes to mind, I am paying for braces for one of my children. So that's one of those things that would be a separate expense. And that's also, that's what goes into there. That's pretty much it. So it's insurance, daycare, after school, or daycare. Basically, um, like either daycare or after school. So it's in order for the person to be able to work. So if you go to work and your child is in second grade and you're paying for after school care, then after school care you will get credit for it if you're the one paying for it. And then it will be split based on the percentages of each person's income. So, but you can do that. FLCourts.org, the form is there. Check the child support guidelines. You can do your own calculations, or you can use the calculator the link in the group, description, or you can also do like Google it, and you'll find other calculators as well. Um, the best way to know the exact number would be definitely doing your own numbers based by hand. That's really what I would recommend. All right, so next up is establishing parental rights. So, and responsibilities. This is very important. Rights and responsibilities. So, this is the process that it's done when let's say you have a child with somebody, but you didn't marry that person, and then you get separated. And then let's say that that person wants to be, to have a particular schedule with the child, and so, or let's say for whatever reason maybe you want to move, and so the dad finds out and he doesn't have rights per se because they're not married. So what he would do, he would file what's called establishing parental rights and responsibility. That is a supplement petition. All the other documents are pretty much the same as a divorce with children. So the number of documents filed and uploaded and created are pretty much the same. The only difference that there's no divorce. It's just, the fact that you need to establish now a parenting plan, you need to establish child support, you need, so that's hence the word of responsibilities and rights and responsibilities, right? A father that hasn't been paying child support and, and hasn't been like consistent with the child or whatever can apply for that, but then he would put himself up for calculated child support and would need to provide a financial affidavit, financial information, and all that stuff. So that's what that process is. Usually it's the father, asking for parental rights. But I've seen an increase of mothers that want to move, relocate, and the father, of the child said, no, you're not moving. So wanting to make things official so that when she does move with the child, she's not left, like she's not left in some kind of custody battle. So she's trying to establish that now, and also at the same time establish child support because in the past the father was not helping anyway. So, those are an example of some of the things that's used. Again, the link for the forms, where all the forms are, they're free, flcourts.org. They're there in the description box. Next up is a financial affidavit. I get asked at least 3 times this question every time. And I even made a video when I send out a quote, no, the documents, the divorce documents to my clients. I even made a video explaining, bro, it's mandatory, and actually the video that I made, it actually goes me searching for the answers. And so what I did for you, it's that if you wonder why do I have to attach, is it mandatory to attach a financial affidavit? I put in the answers that attorneys in Florida, because I'm not an attorney, but the attorneys in Florida have actually done, answering that question because they get the same question we get. So, in other words, the court wants it. Period. End of story. Can we move on? Okay, you still want answers. All right. There is a type of divorce that does not require a financial affidavit. Okay, it's called simplified dissolution of marriage, but it's not that simple. For a simplified dissolution of marriage, both parties have to go to court directly, together, not joining hands, but together, and they have to sign the documents in front of the clerk, and then they have to attend a hearing. Again, both of them, both parties have to be there. What happens if one of the parties don't go? You have to start over again, which is why a lot of attorneys and I know preppers. I mean, when somebody wants to totally avoid the child support, the financial affidavit, I tell them, well, simplified is the best way. Then go grab the, oh, well, she lives in another state. Then you don't qualify. So you got to understand that you have to be together. You have to go to the court together. That's a simplified dissolution of marriage. Again, you want the form, you want to go that route. There's no children, no property, right? There's going to be the simplified dissolution of marriage, basically one document that you sign, but it has to be both parties signing it in front of the clerk. Okay, you're still gonna have the court filing fee. That's gonna change, and in most cases, you still have to wait for a hearing. So you still have those things, and both parties have to go to the hearing. If you can make that happen, and that absolutely, a lot of people get married using that process. We don't help you because there's no point. Why am I gonna help you do something that simple? You just go to the courthouse. The challenge with a lot of my clients, at least, is some of the people are very busy. Most of my clients are super busy, and they don't have time to both people to go to the courthouse and then go again to a hearing again, a few months later, a month later, whatever. They rather do the no court hearing divorce, which of course is what divorce in Florida online we're known for. But in any case, that is an option. If you want to go that route, by all means, kumbaya, do that. FLcourts.org, you can download the form right on there. Okay, or you can just go to the courthouse and they'll write it for you and just sign it, fill it out, and you'll get divorced without having to share your financial assets, and liabilities. Okay, final question for today. Florida resident. So in Florida, you have a requirement to prove that it doesn't matter how long you've been separated, it doesn't matter if you still live in the same house, it doesn't matter where you got married. The court doesn't care about any of those things. The one thing they care about is that one of you have lived in the state of Florida within the last 6 months. And how do you prove it? With a Florida driver's license. Not the lease, not utilities, none of the other stuff. It's a Florida driver's license or a Florida, issued ID. If you don't have that or your spouse doesn't have that, the only other option is an affidavit of witness, which is a document, again, FLcourts.org, link down below. And then you get that as somebody, it could be your family member, it could be a friend, it could be your landlord, it could be anyone that has a driver's license that is longer than 6 months and signs an affidavit saying, yes, I know this person since I know this person is more than 6 months instead of 4. The affidavit is kind of created. You should fill in the blanks. Okay. Again, the form is free, FLcourts.org. That is submitted to the court either along with the case already, or if you already have a case number, write the case number on it, and then you can just file it online, mail it, or drop it off at the courthouse. But that form has to be part of the whole packet, has to be part of the docket. Okay? Without that form, if you don't have a driver's license, the divorce may not happen. Okay? Actually, probably won't. Okay? So that's it. Just pretty good. Those are the 4 questions that I've had this week to address. So I'll be live again next Tuesday afternoon. If you come live, that'll be great. Say hi. Drop the comments, what county you live in, and that will give me an idea where I've been watched from. All right, register. Do all the YouTube stuff, like, share, subscribe. You know the drill. All right, and I'll see you next week. Bye.